Hello, and welcome to this webinar by the University of Utah S.J. Quinney College of Law, presenting an update on the Clean Water Act Waters of the United States, covering the new regulations that have come out, the groundwater guidance, and the County of Maui decision by the U.S. Supreme Court. My name is Robin Cundiss-Craig. I'm the James I. Farr Presidential Endowed Professor of Law at the S.J. Quinney College of Law, and I am happy to present this update. So we'll start by putting what waters of the United States are in the larger context of the Clean Water Act and Clean Water Act jurisdiction. So the Clean Water Act has a very basic prohibition in Section 301 of the Act, 33 U.S.C. Section 1311A, that except as in compliance with the Act, the discharge of any pollutant by any person shall be unlawful. So no discharges of pollutants except as in compliance with the Act. So that takes on greater meaning when you look at what the Act means by discharge of a pollutant, which is a defined term. And specifically, the Act defines discharge of a pollutant to include both the addition of any pollutant to navigable waters from any point source and any addition of any pollutant to the waters of the contiguous zone or the ocean from any point source other than a vessel or other floating craft. So the first important point about Clean Water Act jurisdiction is that it's a multiple element jurisdictional statement. You need an addition and a pollutant to some sort of jurisdictional waters, either the navigable waters, the contiguous zone, or the ocean, from a point source. And when discussing what waters of the United States means, it's important to remember that there are these multiple jurisdictional elements. So a flow chart for the Clean Water Act might look like this. The trigger is the person discharging a pollutant, that is, adding a pollutant to regulated waters from a point source. If not, there is no federal Clean Water Act jurisdiction, and that's why the definition of waters of the United States can be important. If there is a discharge of a pollutant, then the next question that becomes important is what kind of pollutant the person is discharging. If it's dredged or filled material going into the navigable waters, then that discharger needs to get a Section 404 permit, which is the dredge and fill permit, usually applicable to people filling in wetlands on private property. Otherwise, any other discharge of a pollutant is subject to the Section 402 National Pollutant Discharge Elimination System, or NPDES permit requirement, much more common. Now, this distinction is also important because a lot of the litigation over waters of the United States has occurred in the Section 404 context, that is, in people working on their own private property, trying to fill in wetlands, and the Supreme Court has reacted to jurisdiction accordingly. So going through the Clean Water Act waters, the contiguous zone in the ocean, as we saw in the definition of discharge of a pollutant, the ocean very clearly is covered. The reference to a contiguous zone is a reference to the first United Nations Conventions on the Law of the Sea, to which the United States is a party, and that's a 12 nautical mile wide band of ocean waters established under that treaty. More important is the ocean itself, which is any portion of the high seas beyond the contiguous zone, again with reference to that treaty. Under current international law, the United States can regulate what's known as an exclusive economic zone out to 200 nautical miles from shore, and the Clean Water Act technically applies to that entire 200 nautical miles of ocean. More relevant to what's been going on recently, however, are the navigable waters. The navigable waters under the Clean Water Act include the waters of the United States, including the territorial seas. So this is where the phrase waters of the United States comes from. This is the phrase that various regulations and Supreme Court decisions have been trying to define. The territorial seas, on the other hand, are fairly easy. That is defined in the Act, and those are the first 3 nautical miles of the ocean. So if you want to visualize the Clean Water Act's jurisdictional waters, we have the ocean, we have the contiguous zone, and we have the navigable waters. As we've seen, the navigable waters includes the territorial sea and the waters of the United States. I've put all of the oceanic parts of the Clean Water Act in green because federal jurisdiction over the ocean has never really been questioned since the Clean Water Act took its modern form in 1972. Those jurisdictional waters have never been an issue. Navigable waters has a long history as a federal regulatory term. The traditional navigable waters are the waters that are navigable in fact for interstate commerce and waters subject to the ebb and flow of the tide. Now, the Clean Water Act fairly clearly wanted to go beyond just those traditionally navigable waters, but how far beyond is the issue that has characterized trying to define waters of the United States. So let's go through a little bit of a history and an update of the regulations defining waters of the United States. This chart from the Congressional Research Service, which provided Congress with an overview of this history in March of 2019, is a fairly good one. The current version of the Clean Water Act, or as it's more formally known, the Federal Water Pollution Control Act, came into being on October 18th, 1972. This was the first time that jurisdictional waters of the United States were mentioned in the statutory definition. The EPA and the Army Corps spent a fair number of years debating what the waters of the United States should include. The EPA's definitions tended to be broader than the Army Corps of Engineers, but after some litigation and some establishment that EPA was the agency that was actually in charge when push came to shove, in the early 1980s, the Corps and the EPA, the U.S. Army Corps of Engineers and the Environmental Protection Agency synthesized their definitions and have had fairly uniform definitions ever since. As we'll see from this chart, the Supreme Court continued to make decisions about waters of the United States, including its 2006 decision in Rapanos versus United States, which is where our current definitional issues tend to stem from. And the Army Corps and the EPA and the courts have been trying to work out what waters of the United States means ever since. But to start with those 1980 regulations, this again is the Congressional Research Service's graphic providing those initial consensus regulations. So it is the traditional navigable waters, the waters that can be used in interstate and foreign commerce, including waters subject to the ebb and flow of the tide. Interstate waters, including interstate wetlands. Then intrastate waters connected to the Commerce Clause. So any of these intrastate waters that were important in pretty much any way to interstate or foreign commerce were included as waters of the United States. Impoundments of any of those were also waters of the United States. Tributaries of any of those waters, the territorial seas, of course, that's statutory, and then wetlands adjacent to any of the other waters that were there. So this was what I'm going to call the baseline definition. This is the default definition of waters of the United States. That was, like I said, a consensus definition by the EPA and the Army Corps in the 1980s. Now, Supreme Court has also affected the definition of waters of the United States, and there are 3 main Supreme Court cases. The first one was in 1985, United States versus Riverside Bayview Homes, which involved Lake St. Clair. in Michigan, and more importantly, the wetlands adjacent to Lake St. Clair. And the issue really was whether wetlands could be included as waters of the United States within the Clean Water Act's jurisdiction. The Army Corps noted that wetlands are often connected to larger bodies of water. It can be difficult to separate them. The Supreme Court deferred to the EPA and the Army Corps and held unanimously 9-0 that wetlands adjacent to traditionally navigable waters are themselves waters of the United States, subject to the Clean Water Act. This was very much based on the purpose of the act and the fact that if you polluted adjacent wetlands, you were very likely going to pollute the larger waters as well. The next big decision from the US Supreme Court, after some change in philosophy at the court about the Commerce Clause, was the Solid Waste Agency of Northern Cook County versus US Army Corps of Engineers case, better known as SWANCC, which was decided in 2001. This involved Chicago's attempt to have a new municipal landfill. And what Chicago wanted to do was to fill in an abandoned sand and gravel pit that had filled in with water. Initially, the Army Corps said that this abandoned sand and gravel pit was not subject to the Clean Water Act, but then it changed its mind after various citizens made it clear that migratory birds used this abandoned sand and gravel pit. Now, the Army Corps was relying on a gloss to those 1980s regulations in the preamble to the Federal Register notice that said that any waterway that was used by migratory birds would be considered subject to federal jurisdiction and thus subject to the Clean Water Act. So that was the setup. SWANCC appealed and said, no, this really shouldn't be subject to the Clean Water Act. It's not a water of the United States. Again, we're in the Section 404 context of dredging and filling. And the Supreme Court decided 5-4 that SWANCC was correct, that these sorts of isolated waters could not be waters of the United States under the Clean Water Act. This was intruding too close into states' authorities under the Clean Water Act, and the Army Corps was pushing its definition too close to the outer limits of the Commerce Clause. And therefore, this isolated sand and gravel pit could not be part of the Clean Water Act. So the decision from which we are still recovering was Rapanos versus United States, which the US Supreme Court sort of decided in 2006. It was a plurality split court. But again, this involves Section 404 and John Rapanos, who had a large property that he wanted to develop. This property was next to the Pine River, and it had a lot of wetlands and other water features on it. So Rapanos was building drainage ditches, he was bulldozing to fill in wetlands, and the Army Corps asserted jurisdiction over much of the property, claiming that these water features were waters of the United States. And fairly clear, as these photographs indicate, ditching had occurred, draining had occurred to allow this residential development to go forward. Fairly significant split at the Supreme Court with no clear majority decision. The plurality opinion was authored by the late Justice Scalia, and the test that Justice Scalia's plurality put forward was that wetlands are covered by the Clean Water Act when they have a direct surface water connection to relatively permanent waters. Justice Scalia's interpretation focused very heavily on the meaning of a waters, and wanted this relatively limited test. Notably, no federal courts of appeals after Rapanos follow only the plurality decision. Justice Scalia was the plurality because Justice Kennedy agreed that the lower courts had used the wrong test. The Sixth Circuit had used the wrong test. But Justice Kennedy otherwise did not agree with Justice Scalia's opinion and put forth his own test, which was that waters will be considered waters of the United States under the Clean Water Act when they have a significant nexus to traditional navigable waters, such that pollution of the smaller waters can affect the water quality of the larger waters. Now, notably, even though Justice Kennedy was all by himself in this opinion, all of the courts of appeals that have since decided waters of the United States cases have used Justice Kennedy's test. The Seventh Circuit and the 11th Circuit use only Justice Kennedy's test. And in the dissent was Justice Stevens. The dissenters thought the test should be broader. How much broader is open to some debate, maybe as far as the limits of the Commerce Clause, but definitely broader. But as a result, Justice Stevens' dissent concluded that any water that met either Justice Scalia's test or Justice Kennedy's test should be subject to the Clean Water Act, known as the either-or test. So many of the courts of appeals following the Rapanos split followed actually the dissent. You can call this counting noses if you want. There were 8 justices that would follow Justice Scalia's test and 5 justices that would follow Justice Kennedy's test, counting the dissenters. So fairly ironically, it is the dissent and Justice Kennedy's solo opinion that form the basis of Clean Water Act jurisdiction in the wake of Rapanos. So the First, Third, and Eighth Circuits clearly took an either-or approach, and cases out of the Fourth, Fifth, Sixth, and Ninth Circuits indicated that that's probably the direction they are going as well. So here is how that post-Rapanos circuit split played out. The either-or test, first adopted by United States versus Johnson. The Justice Kennedy only opinion on the basis of the Marx narrowest decision analysis was first enunciated by the Seventh Circuit, and these other cases played out accordingly. The Ninth Circuit was the circuit that was the most difficult to follow in some respects. It indicated initially that it was following Justice Kennedy's test, but then in 2011 indicated that it was going with the either-or test. So another thing to remember about our default regulations from the 1980s is this circuit split is still in effect if those regulations ever go back into effect. Now, there was attempted action in Congress to fix the Rapanos problem and the post-Rapanos circuit split. There were various attempts, regulatory and attempts at litigation. But finally, in May 2015, the Obama administration's EPA and Army Corps of Engineers released their finalized Clean Water Rule. This was the next regulatory attempt to define waters of the United States in the wake of Rapanos. This rule had a lot of science behind it, and it keyed itself around Justice Kennedy's significant nexus test, which is where most of the circuits had come to rest as being the most widely accepted test from the Rapanos decision. So in terms of categories, of course, the Clean Water Rule, the 2015 Clean Water Rule accepted, again, those traditional navigable waters. It accepted interstate waters, it accepted the territorial seas, and any impoundments of those three waters. It also recognized tributaries, which it gave a complicated new definition to. It was tributaries of traditional navigable waters, interstate waters, or the territorial seas. And then intrastate waters, it relied on adjacency with a fairly complicated definition of adjacency, again, based on those scientific studies of what waters were likely to have a significant nexus with traditionally navigable waters. The Obama regulation also acknowledged that there would be waters that would be continue to remain subject to a case-by-case evaluation of whether there was a significant nexus, and it excluded a lot of waters from Clean Water Act jurisdiction, including prior converted cropland, which has been excluded from the Clean Water Act since at least 1979. It very prominently excluded groundwater, some ditches, and stormwater management systems. So a fairly complicated rule, but again, trying to hew to that significant nexus test and to scientific studies indicating which waters, based on proximity, were likely to have a significant nexus to traditionally navigable waters. Litigation ensued immediately, and the litigation had two parts. Part one was the litigation over where the rules should be challenged, which courts had jurisdiction to decide, and second part being on the actual validity of the 2015 rule. So there were cases filed, petitions to review the 2015 rule in the U.S. Courts of Appeals. Originally, there were 22 petitions for review filed in 8 federal courts of appeals. But there were also a bunch of cases filed in the U.S. District Courts to challenge the 2015 regulation, including 18 complaints in 13 different federal district courts. The Northern District of West Virginia and the Southern District of Georgia fairly quickly disclaimed that they had jurisdiction over the cases filed there and dismissed their cases. In the meantime, in July 2015, the multi-district litigation panel consolidated all of the courts of appeals cases into the Sixth Circuit. Sixth Circuit was chosen by lottery. In August of 2015, shortly after that consolidation, the North Dakota District Court went ahead and found that it had jurisdiction to review the rule, and then enjoined the 2015 Waters of the United States regulations for the states that were plaintiffs in that case. In October of 2015, the Sixth Circuit then granted a nationwide injunction staying the 2015 rule. In the meantime, the multi-district litigation panel had been asked to consolidate the district court cases, but it decided not to. So it consolidated the courts of appeals cases, but not the district court cases. After granting the injunction in February 2016, the Sixth Circuit then determined that, in fact, it did have jurisdiction to do the injunction and to review the rule. And in April of 2016, the Sixth Circuit denied review en banc of its decisions. After the Sixth Circuit issued its decisions, many of the district court cases were dismissed because those district courts decided that they did not have jurisdiction. But at the time, Georgia versus EPA, which started out as a district court case, was on appeal in the 11th Circuit, and the supplemental briefing was completed in 2016, in April of 2016. And the Northern District of Ohio dismissal was on appeal in the Sixth Circuit. So there was quite the jurisdictional mess by mid-2016. Now that jurisdictional mess did get resolved. The Supreme Court did decide that it was the district courts that had jurisdiction to review these Clean Water Act definitional rules. That case was National Association of Manufacturers versus U.S. Department of Defense, decided January 22nd, 2018. Justice Sotomayor wrote for a unanimous court. They actually came across as thinking this was a fairly easy decision based on the plain meaning of Section 509, which tells the courts of appeals what kinds of cases they have jurisdiction over. And as I said, decided that challenges to Clean Water Act rules interpreting statutory terms must go to the district courts. So that again was based on Section 509B1 of the Clean Water Act, which says that the courts of appeals have jurisdiction to review Section 306 standards of performance, Section 306 categories of new sources, Section 307 standards for toxic pollutants, delegation of NPDES permit authority to the states, promulgation of non-toxic effluent limitations, issuance or denials of NPDES permits, and promulgation of individual control strategies. And basically the Supreme Court looked at this list, said, hey, a definition of waters of the United States is none of these, and therefore the courts of appeal do not have jurisdiction. Go to the district courts. All right, so with that jurisdiction resolved over who could review the 2015 rules, litigation then went on to the rules validity. And at this point, we have two sets of rules at work in various states. So again, the 1980 rules are still the defaults until something else successfully replaces them. But they are limited by the interpretations of SWANCC and Rapanos. The 2015 Obama rule went back into effect momentarily because in National Association of Manufacturers, the U.S. Supreme Court overturned the Sixth Circuit's nationwide injunction because the Sixth Circuit did not have jurisdiction to issue it. However, the District Court of North Dakota did have jurisdiction, and so that injunction remained in effect. In 2018, the Trump administration's EPA and Army Corps issued what was known as the delay rule, trying to delay when the 2015 definition of waters of the United States would take effect. That was overturned by both the U.S. District Court for the District of South Carolina and the U.S. District Court for the Western District of Washington. So the delay rule was deemed invalid. But at the same time, other district courts were staying and overturning the 2015 Clean Water Rule. And on October 22nd, 2019, the EPA and the Army Corps finalized a repeal of the 2015 definition of waters of the United States, but that repeal was itself immediately challenged. So again, a little bit of chaos as to what rules were in effect, as this map shows. So in general, as of late 2019, the states in blue were generally where the 2015 Clean Water Rule was in effect, and the green states were where the 2015 rule was either overturned or held in abeyance, and so the 1980s regulations were in effect. The states with the blue dots were that original injunction in North Dakota versus EPA, with a couple of exceptions. Colorado asked to be released from the North Dakota injunction, and so was released with the stipulation that the 2015 regulations would go into effect in Colorado. New Mexico similarly agreed or asked to be released from the North Dakota injunction, was granted, but without a stipulation as to what rules were in effect. So in 2019, we had the very weird situation where even the EPA was not sure what regulations were in force in New Mexico. The red dots were subject to Georgia versus Pruitt, a 2018 decision that enjoined the 2015 regulations. The black dots were the subject of Texas versus EPA, which invalidated the 2015 regulations in 2019, but only for the 3 states that were party to that case. And then in 2019, the U.S. District Court for the District of Oregon enjoined the 2015 regulations in Oregon. So this was the situation going into the Trump administration's definitions of waters of the United States. So the Trump administration's regulation is known as the Navigable Waters Protection Rule, came out in 2020. Specifically, it was finalized in the Federal Register on April 21st, 2020, although it had been released several months prior to that. It is supposed to become effective on June 22nd, 2020, absent litigation stays. And it focuses on 4 categories of water. The goal of the Navigable Waters Protection Rule is to simplify the categories of waters of the United States. So the first category is the traditional navigable waters, and notably, the 2020 regulations join the territorial seas with the traditionally navigable waters. So basically all of the ocean navigable in fact waters like the Mississippi River and waters used in interstate commerce are all part of that first category. The second category is tributaries, and the 2020 regulations add some interesting glosses to tributaries I'll get to in a second. But again, you're looking at perennial or intermittent tributaries of those traditionally navigable waters. It also includes some other intrastate waters, lakes, ponds, and impoundments, but again, very much looking at the connection of these lakes, ponds, and impoundments, to traditionally navigable waters. And looking at that flow relationship. So if the Obama 2015 regulations hewed to Justice Kennedy's significant nexus test, the Trump administration's Navigable Waters Protection Rule is much more aligned with Justice Scalia's direct surface water connection to a traditionally navigable water. And then finally, because the U.S. Supreme Court upheld 9-0 adjacent wetlands remain included within the Navigable Waters Protection Rule. The Navigable Waters Protection Rule does exclude several categories of waters, 11 categories in all, including dry washes, ephemeral streams, many ditches, including farm ditches and roadside ditches, isolated wetlands, as was ruled out in SWANCC. Prior converted cropland maintains that exception, much stormwater runoff, and smaller water. So a lot of exclusions in the 2020 regulations. All right, so comparing these regulations, I'm going to try and hit some of the highlights and how they do their categorization. So all 3 sets of regulations cover the traditional navigable waters and the territorial sea. Up until the 2020 regulations, the territorial sea was its own category. As noted, the Trump administration's rule makes that all one category, and that is what is known as the traditional navigable waters, which I will abbreviate as TNWs. Notably, the 2020 regulations get rid of interstate waters as a category. That might lead to some interesting developments. The smaller intra-state waters, as noted, the 1980 regulations were based on the Commerce Clause. The 2015 regulations were based on Justice Kennedy's significant nexus test. And the 2020 regulations, much more aligned with Justice Scalia's opinion from Rapanos, applying to lakes and ponds that contribute flow to traditional navigable waters in a typical year, or that are flooded by traditional navigable water in a typical year. Same basic test for impoundments under the new regulations. Tributaries, as I mentioned, the 2020 regulations changed the definition of tributaries somewhat. So it covers only tributaries of traditionally navigable waters that perennially or intermittently contribute flow to those traditional navigable waters in a typical year. So again, very much emphasizing those direct connections to traditional navigable waters, as Justice Scalia did in Rapanos. Some other categories, again, adjacent wetlands included. They have to be because of that very early Riverside Bayview decision. The 2020 regulations define adjacent wetlands as wetlands that physically touch other waters of the United States, wetlands that are separated from those other waters of the United States only by a natural berm, dune, or bank, wetlands that are flooded by traditionally navigable waters, or wetlands that are separated from other waters by artificial dividers if there is that direct hydrological connection. The 2015 Clean Water Rule had put in nearby waters based on physical proximity. That's not a category for the 2020 regulations. Ditches are a much smaller category in the 2020 regulations. The ditches have to qualify themselves as traditional navigable waters, or have to be constructed in or relocate natural tributaries, or be located in adjacent wetlands and contribute flow to traditionally navigable waters. And then finally, the number of exclusions has expanded. There are 11 categories of exclusions in the 2020 rules. There were 7 in the 2015 rules. However, like the 2015 rules, the 2020 rules include groundwater as one of the excluded waters of the United States. So, of course, litigation has ensued. So the 2020 regulations are far from being the last word. As of the recording of this webinar in early May 2020, there are already 4 lawsuits in progress in 4 different district courts. So the first one was filed by the Chesapeake Bay Foundation and Shore Rivers, who challenged the 2020 Waters of the United States regulations in the U.S. District Court for the District of Maryland, which is based in Baltimore. 2 days later, 2 additional lawsuits were filed. On April 29th, the South Carolina Coastal Conservation League and 13 other environmental groups challenged the 2020 regulations in the U.S. District Court for the District of South Carolina, Charleston, which has shown itself perhaps surprisingly antagonistic to the Trump administration regulations in this area. On that same day, the Conservation Law Foundation, the Connecticut River Conservancy, Clean Wisconsin, Massachusetts Audubon, Merrimack River Watershed Council, the Natural Resources Defense Council, the New Mexico Wilderness Alliance, and the Prairie Rivers Network challenged the rule in the U.S. District Court for the District of Massachusetts, which is based in Boston. And then the 4th lawsuit, at least for now, was filed on May 1st, 2020. It was filed by 17 states, led by California and New York. plus the District of Columbia, plus New York City. And they are challenging the rule in the U.S. District Court for the Northern District of California, which is based in San Francisco. So 4 lawsuits so far. Again, the saga of the waters of the United States regulation is far from over. But in the interim, we have another aspect of the waters that are subject to the Clean Water Act that has come up for decision. And this is the County of Maui case and the Hawaii Wildlife Fund, or County of Maui versus Hawaii Wildlife Fund case decided by the U.S. Supreme Court. So in this case, the plaintiffs were the Hawaii Wildlife Fund, the Sierra Club, the Surfrider Foundation, and the West Maui Preservation Association, who filed a Clean Water Act citizen suit against the County of Maui, arguing that the County of Maui was violating the Clean Water Act by discharging effluent without a NPDES, National Pollutant Discharge Elimination System permit, at 4 injection wells at the Lahaina Wastewater Reclamation Facility. So that's the case. The part of Hawaii that is involved, County of Maui, involves more than just the island of Maui, but it is the island of Maui that's involved here. Lahaina is the main city on the west coast of Maui, and the alleged pollution is affecting Kanapali Beach, which is a beautiful beach along the Maui coast. As you can see in the photograph, also has some significant coral reefs along it. So this is the County of Maui's wastewater treatment facility. It's located 3 miles north of Lahaina on that west coast of Maui. The facility receives about 4 million gallons per day of sewage from a collection system that serves about 40,000 people. The facility filters and disinfects the sewage and then releases the treated effluent into 4 on-site injection wells. The effluent then travels about 200 feet underground into a shallow groundwater aquifer that runs beneath the facility, and the wastewater facility typically discharges 3 to 5 million gallons of effluent into the 4 injection wells on a daily basis. Now, the source of the dispute was that the effluent from these injection wells fairly quickly makes its way into the ocean along Maui's west coast, near Kanapali Beach and Kahekili Beach, and that has been proven through a dye tracer study. So 2013, there was a study done. A report was finalized in June of 2013, and it showed fairly conclusively that about 64% of the effluent injected into 2 of the 4 wells reaches the Pacific Ocean starting about 84 days after injection. So less than a year you start, or way less than a year, you start getting the sewage effluent reaching the Maui shore, and you can see that red concentration. There was fairly good evidence from the dye and from nitrate concentrations that the effluent was making it fairly quickly to the ocean. Now, the county of Maui had known that the injection wells would pollute the ocean since it first built the facility. The county actually considered building an ocean outfall to dispose of the effluent directly into the ocean, but decided against that because it would be too harmful to the coastal waters. It opted instead for the injection wells, which it knew would still reach the ocean, but indirectly. So when the facility underwent environmental review as early as February 1973, the county consultant stated that the wells not used, or sorry, that the wells and the pollutants would enter the ocean some distance from the shore, and it confirmed its reassessment of that pollution in 1991. So the county of Maui had known from the beginning that this effluent was going to reach the ocean. The question was, did the Clean Water Act apply? So, leading up to the district court decision, the district court didn't stay the case, even though the county of Maui did go ahead and apply for an NPDES permit. And the district court said that yes, a permit is required. What the district court concluded was that under this court's reading of the Clean Water Act and the court's extrapolation from appellate law, plaintiffs may also prevail if they show that the discharge into the groundwater below the facility is functionally equivalent to a discharge into the ocean itself. That is, liability arises even if the groundwater under the facility is not itself protected by the Clean Water Act, as long as the groundwater is a conduit through which pollutants are reaching a navigable, in fact, water. When it is established that groundwater is a conduit for pollutants, liability may attach to a discharge into groundwater, even if the groundwater itself is not a protected water under the Act. So one of the issues in this case is, what do you do about that groundwater connection? As noted, both the 2015 regulations and the 2020 regulations exclude groundwater as a water of the United States, but the district court said the groundwater could still be a conduit and an NPDES permit could still be required. So after the district court opinion, the case went to the Ninth Circuit, which issued its decision on February 1st, 2018. The Ninth Circuit affirmed, said the 4 injection wells into which pollutants were discharged needed NPDES permits because the pollutants reached navigable waters relatively directly. Notably, at the Ninth Circuit, the United States participated as an amicus and argued in favor of this result. So was in favor of the groundwater as conduit. The relative directness argument, it supported as well. However, immediately after that decision, the Trump administration's EPA issued a request for comments on groundwater as a water of the United States in the Federal Register. And a little more than a year later, in April of 2019, the EPA issued an interpretive statement declaring that discharges to groundwater are never subject to the Clean Water Act. That then became the position that the United States argued to the US Supreme Court in its amicus briefs to the Supreme Court. So the United States itself changed its interpretation of how to deal with this groundwater in the course of this litigation. The opinion or the position taken before the Ninth Circuit was a remnant of the Obama administration's opinion, and obviously the opinion in front of the Supreme Court was the Trump administration's opinion. Oral argument before the Supreme Court took place on November 6, 2019, and the US Supreme Court issued its decision in the County of Maui case on April 23rd, 2020. So the decision at the US Supreme Court was a 6-3 decision. Justice Breyer wrote the majority opinion, which included Chief Justice Roberts. Justice Thomas dissented, joined by Justice Gorsuch, and Justice Alito wrote a separate dissent. So it's a 6-3 decision out of the Supreme Court. And it attempted to strike a middle ground. The majority decision basically declares that both the Ninth Circuit and the environmental plaintiffs, as well as the County of Maui and the United States, are taking two extreme positions in two opposite directions. Interestingly, the textual analysis in the case focuses on the word from. The majority stated that the linguistic question here concerns the statutory word from. Is pollution that reaches navigable waters only through groundwater pollution that is from a point source, as the statute uses the word? The word from is broad in scope, but context often imposes limitation. All right, so basically, can pollutants still be from a point source if they travel through groundwater? And again, the majority was working very hard to find a middle ground between the two litigation positions it was offered. So, as opposed to the Ninth Circuit, the majority concluded that our view is that Congress did not intend the point source permitting requirement to provide EPA with such broad authority as the Ninth Circuit's narrow focus on traceability would allow. So the Ninth Circuit said as long as you can trace the pollutants to a point source, it's covered by the Clean Water Act. According to the majority of the Supreme Court, however, first, to interpret the word from in this literal way would require a permit in surprising, even bizarre circumstances, such as for pollutants carried to navigable waters on a bird's feathers, or to mention more mundane instances, the 100-year migration of pollutants through 250 miles of groundwater to a river. So the court said traceability is just too broad an approach. Plus, it was worried that the Ninth Circuit's test would interfere with states' traditional authority over non-point source pollution and over groundwater. So it didn't want to intrude too far into those state authorities. On the other hand, the County of Maui's position and the United States' position were too extreme the other way and would leave loopholes under the act that the majority did not think that Congress intended. So if you categorically eliminate all discharges to groundwater, no matter what, you are going to create ways to avoid the act's jurisdiction that are just silly. So the court said, consider a pipe that spews pollution directly into coastal waters. There is an addition of a pollutant to navigable waters from a point source. Hence, a permit is required. But Maui and the government read the permitting requirement not to apply if there is any amount of groundwater between the end of the pipe and the edge of the navigable water. If that is a correct interpretation of the statute, then why could not the pipe's owner, seeking to avoid the permit requirement, simply move the pipe back, maybe only a few yards, so that the pollutant must travel through at least some groundwater before reaching the sea? We do not see how Congress could have intended to create such a large and obvious loophole in one of the key regulatory innovations of the Clean Water Act. So both positions were too extreme, and the court wanted a middle ground. Now, along the way, the court also brought up briefly the issue of whether it was going to defer to the EPA's new interpretation that absolutely no discharges to groundwater were covered by the Clean Water Act. And it said fairly emphatically, in fact, twice, no, it was not going to defer to the EPA. First, we do not defer here to EPA's interpretation of the statute embodied in this practice. Indeed, EPA itself has changed its mind about the meaning of the statutory provisions. So the EPA changed its mind, as I mentioned, during the course of the litigation. The court was not impressed. A little later in the case, the court emphasized neither the Solicitor General nor any party has asked us to give what the court has referred to as Chevron deference to the EPA's interpretation. Even so, we often pay particular attention to an agency's views in light of the agency's expertise in a given area, its knowledge gained through practical experience, and its familiarity with the interpretive demands of administrative need. But here, as we have explained, to follow the EPA's reading would open a loophole allowing easy evasion of the statutory provision's basic purposes. Such an interpretation is neither persuasive nor reasonable. So again, not going to defer to the EPA's interpretation, which the majority saw as being too extreme. So the majority's actual holding is that the statute requires a permit when there is a direct discharge from a point source into navigable waters, or when there is the functional equivalent of a direct discharge, going back to the district court's language. We think this phrase best captures, in broad terms, those circumstances in which Congress intended to require a federal permit. That is, an addition falls within the statutory requirement that it be from any point source when a point source directly deposits pollutants into navigable waters, or when the discharge reaches the same result through roughly similar means. So that is the test we get out of the County of Maui decision, the functional equivalent test. Now, the Supreme Court provided some guidance for attempting to figure out functional equivalence. So it emphasized time and distance are obviously important. How long does it take the pollutants to reach the navigable water? How far away was the discharge? The object in a given scenario will be to advance in a manner consistent with the statute's language, the statutory purposes that Congress sought to achieve. So the sixth justice majority emphasized repeatedly the purposes of the Clean Water Act to restore and maintain the chemical, physical, and biological integrity of the nation's waters. So a purpose-based interpretation was validated in the County of Maui decision. In addition, the context includes the need reflected in the statute to preserve state regulation of groundwater and other non-point sources of pollution. So again, the court emphasized, yes, we want to achieve Congress's purposes, but part of Congress's purposes was the cooperative federalism that the Clean Water Act is famous for, and preserving roles for the states as relevant here, states' authority over groundwater and states' authority over non-point source pollution. And then finally, whether pollutants that arrive at navigable waters after traveling through groundwater are from a point source depends on how similar to or different from the particular discharge is to a direct discharge. So again, we're looking for something that is a substitute for a direct discharge, as arguably was occurring in the County of Maui wastewater treatment facility. Could have easily had a pipe to the ocean and chose to use injection wells to delay the discharge just a little bit. The court also provided some factors for lower courts to consider when assessing functional equivalence. In fact, it identified 7 factors that lower courts should consider. These include, again, transit time, the distance traveled, the nature of the material through which the pollutant travels, groundwater or an interim surface water might be more convincing than a lot of earth, for example. The extent to which the pollutant is diluted or chemically changed as it travels, again, tends to indicate that other forces are at work besides the point source. The amount of pollutant entering the navigable waters relevant to the amount of pollutant that leaves the point source. Is only a little bit reaching the navigable water, or is most of it reaching the navigable water? The manner by or area in which the pollutant enters the navigable water, so how exactly does it hit the navigable waters? And the degree to which the pollution at that point has maintained its specific identity. So in a little bit harkening back to the Ninth Circuit, is it fairly obvious that this pollution is coming from the point source you're worried about? Again, Supreme Court emphasized that time and distance will be the most important factors in most cases, but not necessarily every case. So they left open some leeway in case we get the really weird case. But what did they do with respect to the County of Maui's facility to be in this case? They remanded. They said the Ninth Circuit had used the wrong test, and so the case needed to be remanded in light of this functional equivalence test for a reevaluation of the sewage treatment facility. Now, as I mentioned, Justice Thomas dissented, joined by Justice Gorsuch. And their dissent emphasized that the Clean Water Act should cover only direct discharges of pollutants to jurisdictional waters. They argued that the inclusion of the term addition in the Clean Water Act indicates that the statute excludes anything other than a direct discharge. When a point source releases pollutants to groundwater, one would naturally say that the groundwater has been augmented with pollutants from the point source. If the pollutants eventually reach navigable waters, one would not naturally say that the navigable waters have been augmented with pollutants from the point source. The augmentation instead occurs with pollutants from the groundwater. So they wanted a more direct test. Justice Alito also dissented, basically objecting to the test that the court created. If the court is going to devise its own legal rules instead of interpreting those enacted by Congress, it might at least adopt rules that can be applied with a modicum of consistency. Here, however, the court makes up a rule that provides no clear guidance and invites arbitrary and inconsistent applications, so objecting to the test itself. So that nearly concludes our brief overview of recent developments with waters of the United States under the Clean Water Act, leaving me to just one conclusion, that we are still very far from consensus and clarity regarding Clean Water Act jurisdictional waters. Thank you very much.